In contract law, the concept of consideration plays a vital role in establishing the enforceability and validity of a contract. Consideration refers to something of value that is exchanged between parties involved in a contract. It is an essential element that distinguishes a binding agreement from a mere promise. What is consideration? Consideration can be defined as the price or value that a party receives in exchange for entering into a contract. It can be in the form of money, goods, services, forbearance, or any other benefit. In contract law, consideration serves two crucial purposes. Firstly, it demonstrates that the parties have given something of value as part of the contract, indicating their intention to create a legal relationship. Secondly, consideration acts as an assurance that both parties have something to gain or lose as a result of the contract. The Indian Contract Act, 1872, governs the principles of consideration in India. According to Section 2(d) of the Act, consideration is defined as when key elements of consideration, bilateral nature. Consideration must involve a mutual exchange between the parties. Valuable and sufficient. Consideration must have some value in the eyes of the law. Legal and not illusory. Consideration must be legal and possible to perform. It should not be a past consideration, already completed, or a mere illusion without any real substance. Types of consideration. Executed consideration. This type of consideration refers to an act or performance that has already been completed before the formation of the contract. It is a past consideration and generally does not hold legal weight unless it is a formal deed. Executory consideration. Executory consideration is a promise to perform an act or deliver something in the future. The consideration is not yet fully performed by one or both parties at the time of contract formation. This type of consideration is commonly found in most contracts. Unilateral consideration. Unilateral consideration arises when one party promises to do something in exchange for the other party's performance or forbearance. The consideration flows only from one side. Mutual consideration. Mutual consideration occurs when each party promises to provide something of value to the other party. It involves a two-way exchange, and both parties are bound by their promises. Adequacy of consideration. Under contract law, the adequacy of consideration is generally not a determining factor for the enforceability of a contract. As long as there is some consideration of value, the court does not typically question the fairness or equivalence of the exchange. Consideration is a vital element in contract law, serving as the foundation for enforceable agreements. It establishes the intention to create legal obligations and ensures a fair exchange between the parties. Understanding the different types of consideration, such as executed, executory, unilateral, and mutual, helps in drafting and interpreting contracts effectively. By adhering to the principles of consideration, parties can create valid contracts that protect their rights and interests in the eyes of the law.